Hello dear students, I, Dr. Anuradha Goswami, Associate Professor, Department of Commerce from the Bhopal School of Social Sciences welcome you all for this video presentation entitled Historical Background of Business Law in India. Today in this session we will be covering the subtopics like meaning, objectives, branches of business law, sources of Indian business law, history of Indian business law, and then we will conclude our session. Now let us move ahead and let us learn the meaning of business law first. So as you all might be aware of that business law, which is also known as commercial law or a mercantile law, is a body of rules which are established through conventions, agreements which are based on national or international legislation that governs the dealing between persons engaged in commercial matters. Basically, the business law talk about all those provisions which are related to and regulate the opening of a business unit, the running of a business unit, or even the closure of the business unit. Now take a look, the basic reason why did we evolve all these business law. So the objective of business law in India especially are, they basically aim to govern the business activities. They also define the rights, relationship and behavior of business enterprises, and finally they govern the individuals who are doing businesses and those who are also included in the area like commerce, trading and sales of the product and services. Now take a look and put a glance on the scope of business law. The scope of business law basically includes the formation and operation of businesses in India, the law related to contracts, the law related to employment of the employees, the law related to intellectual property rights, and finally any another legal issues that arises out of the normal business transactions. When we talk about the sources of Indian business law, we have basically the four major sources. Since we have been overruled by the Britishers for nearly 200 years, our first source of business law actually comes from the English mercantile law. Then after getting the independence, the majority of our acts have been created or established or enacted by the Indian legal system or our own legislation. Then the third source of business law in India also comes from the major decisions being given by the judges whenever they are settling any dispute related to commercial world. And then finally, few provisions in our act has been created based on the customs and the trade usage done by the people, accepted by the people from the ages in India. Now take a glance and let us discuss that what is the reason or what could be the benefit for creating the business law in India. So we will be talking about only two major benefits for the business law creation is, number one, with the knowledge of business law and business rules and regulation, a businessman can manage his business more efficiently and he even by mistake will not indulge into any illegal activity. And the second point would be that it would become easier for him to understand the legal terms and conditions that are related to his own business transaction and his own business entity. Now take a look into the history of the business law that we do now see in India at the present moment. But as we people have a long history of rules and regulation being there in our country, so our business law actually do involve or do evolve from all those religious prescriptions that have been prepared ages ago. And then after the advent of the Britishers in India, the Britishers were the one who for the first time codified all the rules and regulation related to the business world. After the British rule, obviously once we retain our or we regain our independence, then through Indian legal system we prepared our own business laws. Now take a look at the major business laws that are there in till now they are in vogue in India. For example, when we talk about the major business law, the first one that came into our head is the Indian Contract Act. And if we look into the history of the Indian Contract Act, so we will see or we will find that the Indian Contract Act, its basic first draft was being created in the year 1861. And then this draft was created by the Indian Law Commission. Then this act came into effect in the year 1872, although after its enactment there has been certain changes being made into it. And then the two major act have been created out of the Indian Contract Act, namely the Sale of Goods Act and the Partnership Act. Now, when we talk about another act that is there in vogue is the Negotiable Instrument Act 1881, and if we look into the history of this particular act, so this act was originally drafted in the year 1866 again by the Third Indian Law Commission, and it was introduced in December 1867 in the council, which again it was being referred to the selection committee. The bill was redrafted in the year 1877, and then in the year 1880 the Secretary of State, the bill has been then referred to New Legislation Commission. The draft then has been prepared for the fourth time, and it was introduced in the council and was passed as a law in the year 1881, which we now see. Now take another look into this act that has originated from or repealed from the Contract Act, and that is the Indian Partnership Act 1932. So nothing major history or historical background is this particular act has, apart from the fact that this act has been a part and parcel of the Indian Contract Act earlier, and later on we repealed the provision related to partnership business from the Indian Contract Act in the year 1932. Then we talk about another major act that is there vogue in India right now is Foreign Exchange Management Act 1999, and if we look into the history of this particular act, so we know that this particular act is based on another act which we repealed now. The another act that was being originally created was the Foreign Exchange Regulation Act that came into the year 1973. But since the introduction of the liberalization, privatization and globalization in the year 1991, the government felt that we need to make certain changes in the area of regulation of capital market, including the foreign currency. So instead of FERA, now we framed FEMA in the year 1999. Now, another act and its history that we are going to talk about is the Limited Liability Partnership Act 2008. So, as you all are aware that basically the partnership or the partnership firm, its major characteristics is that as per the law there is no individual identity or there is no discrimination between the existence of the partnership firm and the partner. They mean the same. So that is why the liability of the partners will always remains unlimited. So many people like the sole trader also and these partners also were not happy with this characteristics of partnership. So they wanted to do the business, but they wanted to enjoy this concept of limited liability. So in the year 2008, based on the General Partnership Act, the Government of India created the Limited Liability Partnership Act, in which when a person become a member as a partner in a partnership firm, his liability would be limited only up to the amount of money being invested by him in the business. Now take a look into the another major business law that are still we have in vogue in India is the Consumer Protection Act 2019. If again I talk about the historical aspect of this particular act, dear students, so I just want to inform you that in India, for the first time, when the government thought of giving some rights, some basic rights to the consumers, so they created and they came up with an act known as the Consumer Protection Act 1986. In which we gave basic 6 rights to the consumers, including the consumer protection councils and the quasi-judicial machinery. But then when we people are now aware that the style of purchasing of the consumer has changed, the nature and the structure of the market has also changed. Now we no longer go to the offline marketing, we do many purchasing and selling of a product based on online transaction. Now the situation was our old Consumer Protection Act of 1986 was not having provisions to curtail or to stop those activities which was causing harm to the consumer right by the online seller. So in order to make changes into it, so again a committee was established, and then based on the recommendation of that committee, the government repealed the Consumer Protection Act 1986 and they come up with the Consumer Protection Act 2019, which also included the manufacturer, the seller of a product, the service provider, or even the transporter into the arena, whereby if they cause any kind of an harm to the consumer, they can be penalized as per the provision of this act. And the major area or the major changes that we see in this Consumer Protection Act 2019 based on the 1986 was that though we kept the council as same, the quasi-judicial machinery as same, but then we created two more agencies to look for the promotion and protection of consumer rights. For example, the Central Consumer Protection Authority and the Mediation Cell, which works for the promotion and protection of consumer rights. My dear students, to conclude this session of today, I just want to tell you that business law have been evolving and they will keep on evolving based on the changes that occur in our commercial world, based on the changes that occurred in our information technology area. So our business law will never remain static, they will always be dynamic. With the changes in our marketing and our selling and purchasing behavior, there will be changes in these business laws as well. Thank you for listening to me today. I hope whatever we have discussed to you would be beneficial for you for your studies.